Hi, I hope you are well, and I want us to look at the difference between letters of administration and the probate or the grant of probate. How does the grant of letters of administration arise versus the grant of probate? Now, in administration of estates, we have two types of succession. We have the intestate succession and the testate succession. Intestate succession is where a person dies and does not leave a will, and as such, for his properties and assets to be accessed, any person who needs to do that has got to go through the process of acquiring letters of administration, and these letters of administration will give him authority to administer or distribute the assets of the deceased. What you need to know is that if a person dies and there is no grant of probate or letters of administration, but you meddle in that estate, in other words, you maybe try to sell off a car or tamper with a property or collect rent and appropriate it for yourself, it is actually an offense under the law. So desist from trying to tamper with the properties of the deceased where you don't have the authority granted to you by way of letters of administration or probate. On the other hand, where a person dies and then they leave a will, an application is made to court for the grant of probate, and a will is attached. And when court is satisfied that the people who are applying and the circumstances surrounding the drafting and the execution of that will were valid, then they grant them what they call probate. And by probate, it allows them to distribute the asset of that person as the deceased person relayed in his will. The reason I'm talking about these particular two processes is quite often we get clients at the farm who say, my mother died, I want to sell her land. You ask them, do you have probate? They don't have. Do you have letters of administration? I don't have. And usually we tell them that it is an offense for them to be tampering with the property of the deceased when they don't have the authority granted by either letters of administration or probate. Now, if you're out there and you want your estate to be very organized, I would implore you to write a will, because then in the will you don't get to plunge your family into chaos. You state where you want your properties to go, to whom you want to give a thing you do, whether these are your children or your husband or your wife or your relatives or your particular charities that you prefer. The good thing about the will is that you can actually even record the people who owe you money, how it should be collected, once it's collected, where it should go. You can forgive people debts in your will. You can choose a place to be buried at. So if you're out there and you don't have a will, you should really think hard about having one. And don't think that wills are for only rich people. As long as you are an adult, you can draft down what the guidelines that should take effect once you've died, like where you want to be buried, what should happen to the people who owe you money, what happens to the people you owe money, how are those debts repaid. And so these two processes, probate and letters of administration, are very key when they come to administration of estates. I think if you have any question to do with administration of estates, leave it in the comment, reshare this video, like and follow us, and we shall be coming back with information on more processes in the succession regime. See you.